Good day, Crime Talk aficionados. We have a great show for you today. First, the Eliza Fletcher case. We have a lot to talk about there. Some big news and more questions than answers in the Vallow-Daybell Matter. And what is up with the court in Idaho that everything is a big secret? Also, you may have heard Lori Vallow's son has some of his own legal problems now. And remember when I say people who like kids hang out where you're going to find kids? Here's an example. And then finally, our dumb criminal of the day. Let's talk about it. All right, aficionados, I hope you all had a great long Labor Day weekend. The lovely Miss Kristen and I were able to spend time with the family and friends. Hope it was a great weekend for you as well. All right, a couple of things first. You know the drill. Subscribe if you haven't, like if you do, hit that bell, and remember, you can always listen to us anytime on your favorite podcasting app. Also, normally we do a Tuesday night live. However, because of an unforeseen scheduling event, well, something has to get done that was supposed to get done today, but for the fact it took 2 hours to get a case called up in court today, well, something had to be rescheduled. Unfortunately, it was Crime Talk this evening, so I apologize in advance, but we have a great show for you today. So let's go ahead and open the record for September 6th of 2022. First on the docket, the Eliza Fletcher matter. So a violent felon who's been charged with kidnapping missing mother of two, Eliza Fletcher, had appeared in court in connection with her death. Police have charged Cleotha Abston, he's 38, with first-degree murder and first-degree murder in the preparation of kidnapping after abducting the teacher whose body was found in a dumpster. Now, authorities have not yet confirmed Fletcher's cause of death, but they have identified the body as the billionaire heiress, which was found 7 miles from where she was last seen. All right, let's go ahead and just take a look at the affidavit in this particular case. All right. Now, it's alleged that on Friday, September 2nd, 2022, at approximately 7 a.m., the Memphis police officers responded to a missing person in the 1500 block of Carr Avenue. Richard Fletcher advised that his wife, Eliza Fletcher, went for her regular run around 4 a.m. and had not returned home. She was last seen wearing a pink shirt, purple shorts, and running shoes. At approximately 6:45 a.m., citizens Miles Fortis rode his bike on Central Avenue near Zach H. Curlin Street and found the victim's cell phone as well as a pair of Champion slide sandals laying in the street in the same area. Now, Fortis turned these items over to a family member of the victim, who in turn turned them over to investigators. Thereafter, investigators located video surveillance near 3876 Central Avenue that showed a black GMC Terrain passing and then waiting for the victim to run by. A male exited the black GMC Terrain, ran aggressively towards the victim, and then forced the victim, Eliza Fletcher, into the passenger side of the vehicle. During this abduction, there appears to be a struggle. The Champion slide sandals were found in the same area. The vehicle then sat in the parking lot with the victim inside for approximately 4 minutes before it drove off. The vehicle had noticeable damage to the back passenger taillight area. Additionally, approximately 24 minutes before the abduction, surveillance footage captured the same vehicle in the area and captured a partial plate of DX. On Friday, September 2nd, 2022, the Champion slide sandals were sent to TBI for DNA testing. Thereafter, investigators developed Cleo Abston Henderson as a person of interest in the investigation. DNA found on the shoes matched DNA for Cleotha Abston Henderson in the CODIS database. This led investigators to seek to confirm the whereabouts of Cleotha Abston before, during, and after the abduction. Investigators were able to recover surveillance footage of Cleotha Abston wearing the same Champion slide sandals a day before the abduction. The footage was obtained from the 1080 North Germantown Parkway Malco Theater and was collected by Sergeant Dobbins. Cleotha Abston was found to reside in the 5700 block of Waterstone Oak Way. This location has active utilities in the name of Gwendolyn Brown. Researching law enforcement databases revealed that Gwendolyn Brown has a black 2013 GMC Terrain with license plates BDX7952, and then it lists a vehicle identification number that is registered to her. Investigators also located a police report dated September 1st of 2022 that listed the address in the 5700 block of Waterstone Oak Way for Cleotha Abston. Sergeant Payne and Sergeant Barrett then interviewed the owner of the Majesty Cleaning Services, Marilyn Pickens, who verified that she employed Cleotha Abston and he drives the GMC Terrain, and that his telephone number was 901-825-2028. Investigators obtained cellular phone records for that number, and analysis determined that the cellular device associated with that number was near 3876 Central Avenue during the time Eliza Fletcher was seen being forced into the black GMC Terrain. On September 3rd, 2022, at approximately 10:45 a.m., the 2013 GMC Terrain with license plates BDX7952 was located by members of the United States Marshals Two River Violent Fugitive Task Force. The vehicle was backed into a parking spot in the parking lot in the 5700 block of Waterstone Oak Way and was confirmed to be the vehicle by the license plate number and by the noticeable damage to the rear passenger side taillight. The damage was captured in the video of the abduction and the partial plate identification of surveillance footage. Further, members of the United States Marshal Service Two Rivers Violent Fugitive Task Force observed a male subject matching the physical description of Cleotha Abston standing in the doorway in the 5700 block of Waterstone Oak Way. Officers then detained Cleotha Abston at his location while he occupied the GMC Terrain. When officers stopped Cleotha Abston, he attempted to flee but was taken into custody. Investigators interviewed Chantel Anthony, and she stated that after the abduction at approximately 0750 hours, she saw Cleotha Abston at the home of Mario Abston in the 1700 block of South Orland Street. This is not the house that Cleotha Abston lives. She stated that she saw Cleotha Abston cleaning the interior of the GMC Terrain with floor cleaner and stated that he was behaving oddly. This was later confirmed by Mario Abston, Cleotha Abston's brother, who stated that he too saw Cleotha Abston cleaning the interior of the car with floor cleaner. Chantel Anthony and Mario Abston saw Cleotha Abston washing his clothes in the sink of the house. He stated that it appears that Cleotha Abston was acting very strange. Cleotha Abston declined to provide investigators with the location of the victim, as the abduction was violent, with, as captured on video, the suspect waiting for, then rushing towards the victim, then forcing the victim into the vehicle where she was confined and removed and continues to be missing. It is believed and supported by the facts and physical evidence that she suffered serious bodily injury. Further, it is probable and apparent from the witness statements that these injuries left evidence, examples blood, in the vehicle that the defendant cleaned. And then it is signed. So, first of all, good affidavit, nice, short, and brief. Obviously, this was written to arrest and detain Mr. Cleotha Abston prior to the body being recovered. But a good affidavit, literally no more than a page and a half long, cuts to the chase. You didn't spend 15 pages identifying the statutes that you want to investigate. All right, so let's continue with this story because there's a lot of breaking news with it. So this comes as the former FBI investigator revealed that Abston's first kidnapping victim, Memphis attorney Kemper Durland, worked in the same law firm as Fletcher's uncle, Michael Kinney. This former FBI agent said, "I think this is a very significant clue, and I'm sure that the FBI, the United States Marshals, and the Tennessee Bureau of Investigation are looking closely into this relationship, if there's any." I think this more appears to be just a random act of senseless, violent by a predator, who obviously will give that presumption of innocence. You know how that works. Appears to be he was looking for her. Needless to say, Fletcher's families are understood to have attended the short court appearance, which was adjourned until another hearing set for September 7th. He appeared in court wearing a mask and green-issued prison uniform, swaying back and forth, looking towards the victim's family before telling the court in an affidavit that he cannot afford a lawyer or make bond. Now, Abston did not speak during the short 15-minute hearing and was led away by officers with his hands cuffed behind his back. Now, the ultra runner vanished while out on a jog around 4:30 a.m. on Friday, sparking a 4-day-long hunt, which led officers to several wooded areas across Memphis. The area where the body was found is just 100 yards from the Longview Gardens apartment complex where Abston's brother Mario resides. A van believed to belong to the medical examiner's unit left the scene 6 hours after the remains were found, and it is thought to have been transporting the body. Mr. Abston, who's now 38, has had previous run-in with the law, as noted earlier, and he was only 16 when he and an accomplice kidnapped this coworker, threw him into his own trunk, and tried to force him to withdraw money at a gas station ATM back in 2000. Now, Abston spent 22 years in prison for the crime, and 2 years after his early release in 2020, he is now back in custody for Miss Fletcher's suspected kidnapping and murder. In his victim impact statement of his previous victim, who died in 2013, said he feared for his life during the kidnapping when he was rescued by nearby Memphis Housing Authority guard who heard his screams for help. It's quite likely that he would have been killed had he not escaped. Now, according to the impact statement, the lawyer was alarmed by the teenager's lengthy rap sheet that began when he was just 12 years old, which included charges for theft, aggravated assault, and rape. Needless to say, a lot of people were upset that this individual was released from prison early because, well, if he hadn't been released early, he'd still be in prison. And guess what? In this particular case, perhaps there would not be a deceased woman who had been kidnapped. Just saying, right? Funny how that works, isn't it, ladies and gentlemen? As some people have stated out there, that could have been anybody out jogging that morning, a student, and to find out that this guy was just released 2 years ago for another abduction and gets out and does the exact same thing. Another neighbor around there said, yeah, it makes me sick. She was out yesterday offering to aid in the search when police and a bloodhound were in the area within a couple hundred yards of the body. Now, the violent felon, and we're going to find out more information about this gentleman as things come out, obviously is accused of kidnapping and killing the billionaire heiress Eliza, had stalked the area she went missing from while jogging for almost 30 minutes before the abduction. A neighbor of Mario Abston's has stated that she had seen the suspect at his brother's house nearly every day for the last month. And when Mr. Cleo Abston was in fact charged with the aggravated kidnapping and tampering with evidence following Fletcher's disappearance, officers stated that they have footage of the vehicle used in the kidnapping in the same area 24 minutes before the mother of two was taken at 4:20 a.m. in Memphis, Tennessee. Surveillance footage, which has not been released, apparently shows a man aggressively moving towards Miss Fletcher and forcing her into the vehicle's passenger side. The pair struggled, then the car sat in a parking lot for about 4 minutes with Fletcher inside before driving off, as we stated in the affidavit. Mr. Abston has new charges against him that include identity theft, theft of property, and fraudulent/use of illegal possession of credit and debit cards. Shortly before the discovery of the remains were found, it emerged that Abston has priors for obviously the aggravated assault with a weapon, and sexual assault, all the while he was a juvenile, according to some reports. Mr. Abston's bail has been set at $500,000, and it's understood that he is refusing to cooperate with police. Now, police believe that Miss Fletcher, a kindergarten teacher, suffered serious injury at the hands of Mr. Abston, and that blood was obviously left in the vehicle. His brother, Mario Abston, was arrested on Saturday after officers searched his home when his brother was spotted acting suspiciously by neighbors. Officers found a semi-automatic handgun, a scale, and a bag of heroin and fentanyl He was charged with being a felon in possession of a firearm during the commission of a dangerous felony, and possession of controlled substances. Abston apparently told the police that his brother had been cleaning the interior of his GMC Terrain floor cleaner and washed his clothes in the sink of the house. We'll obviously continue to follow this story. Obviously, it doesn't seem like a whodunit at this point since the alleged kidnapping is on video. The question is, what else is going to be found on video as well? But it really strikes to the heart of the matter. Past performance is indicative of future results. Here you got a guy, went to prison for basically doing the exact same thing, gets out and does the exact same thing. Sometimes you have to wonder. Obviously, yes, the prison sentence is supposed to punish and also hopefully rehabilitate, but sometimes that does not actually happen much. And some people, frankly, do not want the help at all. So it's a tragic case, but I'm telling you, ladies and gentlemen, be careful out there. This is a case that literally could happen to anyone. She was out at 4 a.m. running because she competes in ultra marathons, for goodness sakes. It can happen to anyone. Be careful. Be careful out there. Next on the docket, let's talk Lori Vallow, Chad Daybell. What is the big secret? Remember I told you something big was going on at the hearing last week in Idaho in regards to the Lori Vallow, Chad Daybell matters? Well, we have a little bit more information. Guess what the court's reason for sealing the proceedings was? Yes, that's correct. Under the Rule 32, finding that the likelihood exists that both the state and the defense could be prejudiced by discussion or dissemination of information already sealed, the court finds that a compelling interest is at stake in a need to preserve a fair trial, and no reasonable alternative exists to protect this fundamental right except to conduct a closed hearing at this time. The court will also hear the sealed motion to intervene, as the issue raised therein are interrelated. For the same reason set forth above, that motion will also be heard in the closed hearing, and all the recordings of the proceedings shall be sealed. The motion hearing was scheduled for August 30th. Now, the closure in that hearing is for the limited purpose and is no broader than necessary to protect the party's interest in preventing the disclosure of potentially prejudicial information or to injure the party's right to a fair trial. Well, what are those issues? The state is apparently filing motions under seal regarding counsel in regards to Mr. Pryor, Chad Daybell's attorney's representation of the defendant and the defense motion objecting to that, which has been filed under seal. The court also was going to hear the motion to intervene, but you wouldn't invite the party that filed the motion to intervene, and you're just going to have a closed session? It raises a lot of questions. What is so prejudicial that can't be discussed in open court? Why is the defense not objecting to everything that's been sealed? Why is the state trying to disqualify Mr. Pryor, the counsel for Chad Daybell? Why can't Lori Hellis, who actually filed the motions to intervene, be present? Now, the judge also issued an order on that. He said intervention may occur in civil cases, not criminal proceedings, as indicated by both the absence of corresponding criminal intervention rule and as determined by the Idaho case law. And he cites some case law that says, we agree with the Court of Appeals. The only parties to the criminal action are the state and the defendant, citing Idaho Code 19-104. A criminal action is prosecuted in the name of the state of Idaho as the party against the person charged. As crime victim is not a party to the criminal case, the victim cannot intervene in defendant's criminal proceedings because, unlike Idaho rules of civil procedure, the Idaho rules of criminal procedure don't provide process for intervention. And he cited this Johnson case that the Supreme Court in Idaho ruled upon. The inability of non-parties to intervene in criminal cases recognizes that the considerations underlying intervention in civil cases are not applicable to criminal proceedings. Isn't that convenient? Accordingly, the rules of civil procedure provide no mechanism for non-parties to intervene in criminal cases, and on that basis alone, the motion to intervene under the Rule 24 must be denied. And then addressing Hellis's motion to intervene under Rule 32, proves that the public with access to the Judicial Department's declaration of law and public policy and to access the record of all proceedings open to the public. Basically, what they're saying is our clerks are too busy to deal with these types of things, and we can't have the clerks interfere with the judiciary by making public records available to everybody. Because, that's really difficult in today's world. Like you scan them, you put them up on the cases of public interest where you could put everything up there. It's amazing modern technology. But that's the other reason that Judge Boyce gives, and basically says, yeah, we just can't have our clerks. We're too busy. We're too busy. Sealing records, of course, okay? And when you read the statute, and I could go through it line by line, word by word, but it's really kind of boring. But the bottom line is the court creates a situation where he says, well, there's no rule for us to deal with this. But it's also not uncommon where there's no criminal rule of procedure, then you can also look to the civil rules of procedure. Now, we're not asking them to say, hey, make me a party like you would in a civil case saying, I want to intervene. I have a great interest in here. Basically, what Lori Hellis has been doing is saying, Judge, I just want you to follow the law. And since neither the defense nor the prosecution is saying, hey, Judge, we want you to follow the law for whatever reason they're going for, she's saying, hey, Judge, you're not following the law. So if the prosecution and the defense isn't going to call him out, then guess what? She is going to do it. But of course, the judge says, we just can't do this because Lori Hellis, we don't even know what she wants. So if she would like to provide a list of everything that she want access to, maybe we'll consider this. I can tell you that motion's been heard. It's been filed, but it's in limbo. Nobody's accepted it for filing by the court. Isn't that interesting? Why, ladies and gentlemen? I'm just telling you, I don't care whether you think Lori Vallow is absolutely guilty or if you think she's innocent, okay? The point is the public has a right to know. These are public proceedings, okay? And for the judge to limit this is basically saying to the world, we don't care what you think. We're going to do it our way. And I'm telling you, in my years of practice, I don't think I've ever had a hearing that has been sealed in an adult criminal case. And I qualify that with an adult hearing because if it was a juvenile, then they do some things that they seal the courtroom out. But cases have been reversed when the court closes the courtroom and it's no longer a public proceeding. I do not know why, and maybe the defense is objecting to it, but it appears as though they are not. But they should be jumping up and down saying, no, we want a public hearing. The public has a right to know. It is reversible error, and I do not understand why. And it may not be till it gets through the Idaho courts, because apparently it kind of seems like nobody really cares out there what's going on. Maybe Mr. Pryor's motions that he lost and then went up on appeal, we will get a little bit of play there. But somebody in the actual case needs to make a point to say this is a public proceedings. The victims have a right to know what is going on with their case. If the case is in jeopardy, why should that be done behind closed doors? If the evidence is overwhelming, why should that be done behind closed doors? If there is misconduct alleged by either the defense or the prosecutors of opposing counsel, why should we not be allowed to do that, to know that? Because it could be embarrassing. Well, those allegations were made early on that there was a situation where the defense thought that Mr. Woods was behaving unethically. I looked at the evidence and I concluded that it was not, in fact, unethical behavior by Mr. Wood. But I don't know what the new allegations are, so I can't say that they're doing everything appropriately. Just like I can't say the defense is lobbing grenades appropriately or not, okay? It needs to be opened up. Hopefully, the court is ultimately going to address the issue. I think the court finally realizes that he has to make a record in accordance with the law. Basically, what this boils down to, ladies and gentlemen, is enough is enough, because this needs to be unsealed. It needs to be made available to the public. The court's not going to do it. How can we have any trust whatsoever in the process? All right, not trying to beat a dead horse there, but I'm telling you, it's concerning to me. It's concerning, and it's just another issue that's going to be brought up on appeal. So I just don't understand this good guy thing that Judge Boyce is trying to do, protect both sides. It's a criminal case where the people are charged with multiple homicides. It's going to be prejudicial information, okay? I've made that objection. You know, I object. This evidence is prejudicial to my client. It's called the evidence, okay? I just don't get it. And a lot of people are trying to get me to go down the road saying, well, it's all because of the church that's running the show out there. I don't have any evidence of that, but it's certainly making me start to wonder and go, And I'm not I am not a conspiracy theorist. I am all about facts. But when they're being held, suddenly people start creeping down the conspiracy lane when people don't want to talk about the facts. In other news, it appears that Lori Vallow's son, Colby Ryan, well, he's been arrested for an alleged sexual crime. Now, according to court records, Ryan was booked into the Maricopa County Jail in Arizona over the weekend on 2 counts of domestic violence sexual assault charges. Now, a probable cause statement shows a woman contacted the Mesa police on Friday to report an alleged crime. She told officers Ryan had visited her 2 days earlier. During the visit, she said the pair watched television together and that Ryan pressured her to have sexual intercourse. She told him to stop. This isn't a good idea, and I don't want to do this, but he proceeded to assault her, according to the affidavit. The victim then said that the defendant said he was sorry and started to cry. The victim went into her bedroom and locked the door while the defendant slept on the couch, according to the affidavit. The next day, the victim recorded a conversation with Ryan, and he agreed that he had sexually assaulted her, according to the affidavit. A nurse completed a sexual assault exam on the victim, and clothing was also tested for DNA. Police have arrested Ryan as of Saturday evening, and during an interview, court documents indicate he made verbal admissions to sexually assaulting the woman, even after the victim told him to stop multiple times. He's being held on a $10,000 bond. He's expected to appear in court, which he did today, where the bond was set. Charges expected soon. Formal filing of charges will be soon. For those who don't know, Lori Vallow is Ryan's mother, and her husband, Chad Daybell, are charged, obviously, in the case in Idaho that we've previously talked so much about. Ryan has been very vocal with his concerns about his mother's conduct. And you may ask, well, what does this really matter? Well, there were jail calls where Ryan spoke with his mother. They would need Ryan to come to court and to talk about this. And since Ryan's case will probably be over before Lori Vallow's case, one little thing in the whole big cog of the justice system that could throw an issue into peril for the prosecution. If he's not convicted of a crime, he won't be cross-examined on what he has allegedly done. He's presumed innocent. But the DA may not want to call him just for the mere facts that he may have this case pending. And additionally, if he's convicted, you don't necessarily want that as your strong witness in the case. Why? Well, because if you are a felon and you testify, there's a jury instruction that is given that says you have heard testimony from a person who has a felony conviction. You may consider that in making your decision as it relates to his or her credibility. So basically it says if you have a felony conviction, take it with a grain of salt. We will continue to follow that case, as I'm sure you can imagine. Next on the docket, remember what I say about people that want to be near kids, that like kids, they like to hang out near kids? Just saying. Don't get me wrong. I mean, I love my kids, but young kids, you don't want to hang out with somebody else's kids. That was just weird. Why would you do it? Well, New York police are questioning a 20-year-old ice cream truck driver after he allegedly arranged a meeting with a 10-year-old girl on social media. Investigators said the pair met up in person Sunday afternoon in Staten Island, and the girl went home afterwards. When she arrived home, her mother called 911. Police initially said the incident was reported as an abduction. The girl reportedly told officers the ice cream truck driver grabbed her by the wrist and dragged her into his truck, but she broke free and escaped less than a mile away. Police then said on Monday that the incident was not an attempted abduction. The police also said the driver was still in custody and charges were still possible. And finally today, our dumb criminal of the day. A St. Petersburg man was arrested Saturday after he threatened the supervisors of elections in that particular county last month. Now, the Largo Police Department said Charles Henry Westgate, who's 68, called the supervisor of the elections on August 8th about issues with his voter identification card. During his conversation, according to the arrest affidavit, it said that Mr. Westgate allegedly became irate and said he would bring a grenade to the office if his issues weren't resolved. Police said the call taker supervisor then had a second conversation with Mr. Westgate to assess his threat's seriousness. The arrest affidavit said Mr. Westgate told the supervisor that he would bring a grenade to the office and asked, "What? Are you scared? Are you going to hide under your desk?" He was arrested on Saturday on a charge of making a false bomb threat against a state-owned property. Police said he denied the allegation after being advised of his rights. So now we have a good old-fashioned swearing contest, unless, of course, it was recorded. Needless to say, if you're calling up where somebody feels concerned, not one but two people are saying that you have, in fact, threatened them with bringing a grenade to the office, well, you're dumb, okay? I think it's a little bit more than just a misunderstanding. So, Mr. Westgate, you are a dumb criminal of the day. All right, I want to apologize in advance. No live tonight, no Patreon. Thank the inefficiencies of the court system. When you show up at 1 o'clock and you don't get your case called until 3:15 because they got to take the in-custodies first, well, let's just blame the Jefferson County court system today. Apologize for that. Anyway, because I was unable to do what I had to do during that time period, I got to do it this evening. So I apologize. We'll see you next time on Crime Talk.